She told me we have 2 more minutes, so I'll wait those 2 minutes. I think we're in good shape. So I want to thank you all for coming. I'm Rodney Ellis, and welcome to the John and Hazel Biggers Center. We're glad to have you here. I want to thank my staff, first of all, for pulling this together on very short notice. Give them a very warm round of applause. I know about 2 or 3 people told me they just got a notice sometime today, and I must admit I'm the culprit. I got a notice. Somebody sent the email and maybe a text message to me, and I don't always get around to reading my text messages or emails, but they're going to have an event at the University of Texas Law School tomorrow in honor of the 75th anniversary of Sweatt being admitted to the law school in 1950. And so one of my classmates, Clotilde Haynes from Worthing High School, a couple years ahead of me, who pretty much wrote our thesis to get out of the LBJ school. We had a joint project, and I did the talking. So what we did back in 1977 was do the minimum housing standards, increasing the standards, raising the standards for the city of Austin. So I kind of worked the politics, but I wasn't all that good on the writing. So she said, "Are you coming?" And I said, "What?" She said, "Well, the precursors are having this event to thank Sweatt for what he did, for being bold enough to do that, and Thurgood Marshall and all the other people who opened those doors." And then she said, "Rodney, like the doors you walked through to go to the LBJ school." And the precursors were having it. I said, "Well, Clotilde, I'm tied up." She said, "Well, no, you a precursor." I said, No, that's for you old people." And she said, "No, they consider the precursors at the University of Texas, those who went from 1950, who got in, who started at UT. If you studied at the University of Texas and you happen to be African American, between 1950 and 1975, then you're a precursor." So I was only there 1 semester to qualify as a precursor. So I'm going to go tomorrow. But I thought about it, and I said, in Sweatt's hometown, we should do something here. And we're talking about, staff, was that 5 days ago or a week ago? At most, a week ago. So we pulled this together on short notice. I'm not going to do any more talking tonight. I'll give you a couple of important factoids. That case showed the brilliance of Thurgood Marshall and his legal team. In that era, you would not have started by trying to integrate swimming pools or kindergartens or middle schools or high schools or even undergraduate universities. They were hopeful, the legal team headed by Thurgood Marshall, that the courts and the American public were willing to accept African Americans, which in turn opened the doors, Representative Wu, for Asian Americans, for women who'd been excluded in many circles, for Hispanics and others. But they thought that if you started with graduate school, you could do something. And that was a tremendous effort to go and find plaintiffs. That was not an easy thing to do. Mr. Sweatt was a bit older than the average law student. One of the panelists may tell you a little bit more about his story a bit later. But he was the one bold enough to be the lead plaintiff in that case. He was technically not the first African American to go to the University of Texas. It was actually another Houstonian, John Chase. And the reason John Chase, the architect, first black architect in Texas, undergrad from Hampton University, he went to get a master's. He applied for a master's in architecture. And architecture school started in June. Law school started in August. There's a picture on the back wall there behind our young Vincent Elkins lawyer, Cornell grad and Harvard grad. That is Virgil Lott. Virgil Lott, out of the African Americans who started in that class in 1950, he was the one who graduated first. You just have to roll back and imagine the taunts, the pressure, the death threats that they had to endure. But Virgil Lott was the first African American to graduate from University of Texas Law School. I know Dean Douglas will talk to you about it a little later, but I'll give you this little footnote. Thurgood Marshall made the decision for Texas somewhat different from Louisiana. When he sued the state of Louisiana to integrate, they decided to settle that lawsuit and get significant funding to start what is now Southern University in Louisiana. We take interns in our program, Judge Dennison, from Southern as well as Texas Southern and other law schools. But Southern University in Louisiana, they have a commemoration of that lawsuit on the wall because Thurgood Marshall decided it was so hard fighting that crowd in Louisiana, he better take that law school and do the best that he could. I want to thank Representative Ron Reynolds in case he's still here or if he has to leave early for coming. I think, Ron, you're still here. He might have tipped out. Constable Smokey Phillips, Judge Linda Dunson, who was one of our TLIPers interns. Thank you, Judge, for being here. HISD trustee Myrna Guidry, and of course, we're going to recognize representative on the panel a little later, and Dr. Carla White, the treasurer of Harris County. Thank you, and let's all be so proud that we take the time to honor Heman Marion Sweatt. With that, I'll turn it over to Congresswoman Erica Lee Carter. Give her a warm round of applause.
Good evening. It is an honor to be part of this historic evening. Whenever we celebrate something that is 75 years old and helped lead to the careers of so many in our community and nation, we should always ground ourselves that we are being part of history and we're going to carry forward and build on this legacy. And we have such an outstanding panel, so I'm going to talk less, but I know it's flashing, but I do at least want to, they haven't seen their slides, but I do at least want to make sure everyone, as they say, knows their names. So we have President Danielle Landers of the Houston Bar Association, who made history as the first African-American, but I say black woman, to lead the organization, only the 7th woman in the 155-year history. And she's, of course, a respected leader, civic leader, and has a strong commitment to diversity and advancing the legal profession. Very excited. President Landers. We have Mr. Jonathan Fombon. I usually call him John, but he is our Deputy County Attorney and First Assistant County Attorney for Harris County. He oversees many legal divisions and manages our high-profile litigation, including many lawsuits against our own state of Texas, against Attorney General Ken Paxton, and even up to our United States Supreme Court. He went to the University of Michigan, and he remains deeply engaged in helping our Harris County residents. Thank you. We have the Dean, the President, Dr. James Matthew Douglas, a distinguished professor of law at Texas Southern University's Thurgood Marshall School of Law, where he has taught since 1981. He was the former president of Texas Southern University, for those who do not know. He co-founded its Urban Research and Resource Center. He is nationally respected as a legal scholar and very dedicated to advancing justice, equity, and the next generation of lawyers. Dean Douglas. We have Miss Aljanita Scott Davis, Esquire. She is, this is not right, sorry. She's with the Downtown Management District. She has served as the president of the National Bar Association, general counsel for the Port of Houston Authority. She has worked in community affairs at J.P. Morgan Chase. She's also taught at Texas Southern University, and she is a historian de jure, Miss Aljanita Scott Davis. And now we have a great leader, Representative Jean Wu, State Representative Jean Wu, and currently the Democratic House Caucus leader, who has served since 2013 in District 137. He was a former Harris County prosecutor. He now is in private practice. He earned his degrees from Texas A&M University and the University of Texas at Austin and South Texas College of Law, and remains a strong advocate on civil rights, immigration, and education. Leader Wu. Okay. I know our great Commissioner Ronnie Ellis, gave a little bit of history, but we want to get a few more details. So our first question, How did the Supreme Court reach their decision in Sweatt versus Painter? And what impact did this decision have on desegregation and the civil rights movement? I'd probably like to start with Mr. Fonbon and then maybe go to Dean Douglas.
Here we go. So the case of Sweatt v. Painter that I think many of you are familiar with involves an applicant to the University of Texas Law School, a black applicant from here in Houston. And in that case, the University of Texas Law School rejected him specifically because he was black. They said that to him. And so he brings this lawsuit, and it's actually a state court lawsuit tried here, I think, in Texas. And during that proceeding, the University of Texas gets ready for its defense. And what they do is they say, you know, the law at the time was if things were separate but equal, that was okay. And so they decide to have the legislature create a new law school for blacks only that would also be in Austin. Later down the line became, I think, TSU Law School, Thurgood Marshall Law School, but at the time would have been in Austin. And that was going to be their primary defense, which was under the separate but equal doctrine from the case of Plessy versus Ferguson, there's no problem here. And eventually reaches the US Supreme Court, and the US Supreme Court says, sure, it's separate and it's a law school, but it's certainly not equal. It doesn't have access to the same resources, the same professors, the same job opportunities, and therefore we're not overruling Plessy versus Ferguson. We're not saying that that case law is improper. However, it is not separate but equal, it's separate but unequal. And that case lays the groundwork for Brown v. Board and of course many cases afterwards, and I'll turn it over to the professor to talk about what happened next.
All right, let's look at leading up to the lawsuit. In 1938, there was a lawsuit in Missouri. Lloyd Gaines. All right, that was beginning. And it was important because at this time, if you were an African American and you wanted a PhD, a medical degree, a law degree, there was no place in the South for you to go. And basically what most of the states did was they either paid your fees, all of them or a portion of them, wherever you could get into law school. So if you look in the South prior to the 50s, most of the African-American lawyers and doctors went to Harvard and Yale and other Ivy League schools paid for by their states. But a part of the architect of defeating segregation was to first show that it was not equal, that the law required that if you're going to be separate, it had to be equal. So what Gaines did was he sued to get into the University of Missouri. And the Supreme Court ruled that the state of Missouri had to provide an opportunity for Gaines to go to law school within the state of Missouri. So Missouri set up a law school at Lincoln University. Thurgood and the NAACP appealed that case to the Supreme Court. While they were waiting on the rehearing, Gaines disappeared and has never been seen again. All right? So when people say it was difficult for the NAACP to find a plaintiff in the Sweatt case, it's true. Because nobody knows what happened to Gaines. So it was hard finding a plaintiff who wanted to take that chance. And so, but your question had to do with how did the Supreme Court make the decision? It's kind of strange because the Supreme Court set up a test that could not be met. Because remember, when Sweatt filed the suit in '46, the state of Texas knew they had to provide an opportunity within its borders for Sweatt to go to law school. And so when they asked for a continuance, they said, continue the case and let us set up a law school. So they quickly set up a law school all right, in about 5 or 6 months. Okay. And in 47, they started the law school. When the case reached the Supreme Court in 1950, which was 3 years later, they only had one graduate. So the Supreme Court basically said, this isn't equivalent to UT. You only have one graduate. You only have a handful of library books. You don't have any respectful alumni in the legal profession. So they set up, they're comparing a 3-year-old law school to a 75-year-old law school. And they're saying they're not equal. So in a real sense, if I had been a lawyer, I would have wanted to appeal the Supreme Court decision because they really set up, I'm glad they did, but they set up a test that couldn't have been met for a 3-year-old law school, comparing it to UT. I would argue that if the programming was the same, if the financing was the same, if they had the same opportunities at this new Texas State University for Negroes, then the law schools were equal, not if they had the same product, because there's no way you could produce in 3 years what another law school had produced in 75 years. But I'm glad they reached that decision.
Right. And on top of that, the law school was set up, as a colored law school in Austin. So they found 3 people who lived in Austin to go to the colored law school. So Sweatt could not go and enroll in the colored law school. He was trying to desegregate the University of Texas Law School. So he would not do that. So once they found that it was really difficult to try to maintain the colored law school in Austin, they said, well, where else could we put that school? So they had hearings.
No, Aljanita, let me correct you.
Oh, my. He's setting the record straight.
The decision was made in June of 47 when they purchased Houston College for Negroes.
From HISD.
Right. Okay. No, from the University of Houston. Then
We
in 34, the University of Houston split. Okay. All right, so they created, they purchased Houston College for Negroes in 1947. They purchased it in June of 47. They opened the doors as Texas State University for Negroes in September of 47. That was already existing university. All right. What they didn't have a law library, nor did they have a law faculty. So the real reason it was in Austin was that they used UT faculty members and library facilities in Austin for the law students. And during that 1947-48 year, they hired a law faculty and they created a facility on Houston College for Negroes campus for them, and they moved the law school to Houston in the fall of 48. So that's, and the reason.
However.
All right. It wasn't so much that Sweatt, we don't know what Sweatt wanted to do. We know that the Thurgood Marshall and the NAACP did not want Sweatt to go to Texas State University of Negroes. In fact, Thurgood always referred to as the Negro Law School because Thurgood was interested in integration and not having a new law school for African Americans anywhere.
Yeah.
The one student that came from Austin and ultimately graduated was Henry Doyle. And Henry Doyle was at the law school in Austin where
Right.
he enrolled at the Colored Law School.
Right.
And they moved the Colored Law School in a pickup truck. And he followed the pickup truck Yeah, it was followed the pickup truck. The whole law school was in the pickup truck. He made sure he didn't want to. He followed the pickup truck to Houston, and it was Lulea Harrison and Lulu White who went before the state legislature to say, if you are going to put a law school somewhere, put this law school at what was then Houston College for Negroes, that they then converted to Texas State College for Negroes. Right, which had 2,500 members back then. And if you graduated like my mother did in 47 from Houston College for Negroes, they allowed you to turn your degree in so the state of Texas could get credit for educating you, which it hadn't. And so her degree says the University of Houston has authorized the Texas College for Negroes, which she hadn't attended, to award the degree to Althea. So that allowed Texas then to take credit for having educated anybody who had attended Houston College for Negroes.
Wow. Wow. What a rich, complicated, as it should be, process and story, and thank you. Commissioner Ellis mentioned some of the students that entered with Sweatt. I want to say the other names. I don't know if they all graduated, but we had, of course, Virgil Lott, he mentioned, George Washington Jr., Jacob Carruthers, Elwin Jarman, and Dudley Redd. Those were the first black students that enrolled in 1950. Where are the women? Well, in 1951, Gloria Bradford became the first black woman to graduate from UT Law and the first black woman eventually to try a case in the Harris County District Courts in 1954. So we want to remember them as well. So my next question, I'll throw to Representative Jean Wu first. How did this ruling lead to diversity in the legal profession? And why is diversity in this profession so important?
You want to give me something I can answer?
Okay, well, you can pass.
I haven't been around that long to be able to properly answer that. I'll say this. The legal profession is one of the last professions to really, let's just be honest, be integrated. If you go look at the major law firms, 10 years ago, easily all the major law firms, every partner was white. There's occasional woman, an occasional Latino, occasional black person, but relatively still very, very segregated and very self-segregated, right? Within the last 10 years, different firms, especially like firms like Greenberg Traurig, who have made it a point to hire and promote minority attorneys. You can see a big difference in their boards and in their partnerships. I'll tell you this, this is one of those places where there's still a lot of societal stereotypes and issues. I'm very proud of my time in the DA's office, and you know, one of my more memorable cases was trying this very difficult domestic violence case where there was very little evidence. It was a he said, she said, but it was going off of abuse that's occurred over almost 2 decades. And we wanted justice for this lady, and we thought for sure we were done. And the jury came back with a fast guilty. And when we went back to the jury room and talked to the jury, and we like to poll them and say, hey, how did everyone do? Everyone's like, hey, you did a great job. You made the story pop. You made the witness believable. And then we get to this one white lady, and she looks me straight in the eyes and says, I'm just so impressed you spoke English so well. And that went from one of my highest points in my career to the lowest point in my career, in a span of about 30 seconds. And it's things like that. We still have this issue of it's not just the legal ability to go to law school and to become lawyers. It's also the societal ability to be treated as an equal, right? It's more than just the bare law. It's also like, if a black man graduates as a lawyer and gets licensed as an attorney, does he get treated with the same respect, right? And I think everyone can answer that for themselves. I feel like when I'm an attorney, like being an Asian American, I see around me sort of the issues, like Asian women especially get talked down to, get always treated as the assistants. They're treated as little girls, even though they're like a 47-year-old partner of a major law firm. But it's those kind of, we bring into our professions the biases, the hang-ups, and the racial animus that we kind of keep quietly in the neighborhood, right, at our home. And those things kind of spill out. And I think what I want, my point to talk about all this stuff is I'm really so glad that these experts, not me, experts are here to talk about this issue, because the point that I want to bring up to everybody is this shit ain't long ago. This was not that long ago. Everyone talking about civil rights like it was the last millennium. Well, it was the last millennium, but it was not 1,000 years ago. This is within a human lifespan. And right now, I mean, like, we're fighting stuff about civil rights that we didn't think that we would have to fight again. I mean, we're literally, in the guise of anti-DEI, we are rolling back protections for minority students who have spent almost a century trying to break into those institutions and force them to allow them in. And after we force them to allow them in, they still put in provisions that say, we're gonna, even though we legally allow you to be here, we're still gonna make your life as hard as possible. And then we put in provisions that says, no, you're not. You're not gonna do that. You're not gonna purposely make things hard for Black and minority students. We are rolling those protections back. And we're talking about it in the guise of, well, we're just making things more equal. Things have never been equal.
So I attended the University of Texas Law School as well. I started in 1993, and that's critical because that was the year that 4 white students filed a lawsuit against University of Texas Law School, alleging that they were discriminated against because minority students had taken their spots. So the NAACP Legal Defense Fund tried to intervene on behalf of our class in 1993, but that intervention was denied. The case went forward, and then in 1996, the Hopwood case, so it was the lead plaintiff in the Hopwood case was a woman named Cheryl Hopwood, and in that decision, the US Supreme Court for the first time actually ruled against the law school and its affirmative action program. So I've seen since then a rollback of the decisions that were created to help minorities. Just to give you a sense of what these decisions do, the year that the Hopwood case was decided, University of Texas admitted 1 Black student. So when you think about the year that I was admitted at University of Texas, there were 27 of us out of 525 students, 530 students. And then, a matter of 3 years later, there was only 1 student admitted to the law school. So these decisions have significant impact. I do have to say, even despite all of that, despite everything, the numbers have not changed significantly. So statistically, Black lawyers haven't really increased significantly. So if you look at the number of Black lawyers from 1970 to the 2020s, 2020s, it's gone from 2% of the legal industry to only 5%. We've seen very little change, and actually from 2014 to 2024, it stayed at 5%. So we haven't seen a lot, and I think that these anti-DEI initiatives are going to further roll back those any progress that we've made as well.
Yeah, I'm going to say this. Hopwood was a setup. And I'm going to tell you why Hopwood was a setup. The chairman of the admissions committee at UT, that I know personally, the way the committee and admissions was structured was clearly unconstitutional, and he knew it. They knew that the way they set their admissions up was unconstitutional. The other reason I say it was a setup, I talked to the assistant AG that worked on the case. If you read the Howard decision, and one of Rodney's friends wrote the opinion, he's my friend too, I'm just kidding. But when you read the opinion basically states that the LSAT is 100% predictable in terms of success in law school. Even though they tell you it's not, when you read the opinion, it's almost that. And I asked, why didn't you all question the validity of the LSAT? You know what he told me? The University of Texas Law School told us not to raise that issue. People don't believe, out of all the major lawsuits dealing with admissions, both in medical and in law, the only case that raises the validity of the test is the Michigan case, the Grutter case. That's the only one that raised the validity of the test, because they wanted to win. All the other people didn't want to win.
Wow. The setup. Thank you. My next tribute before my question is to J. Vance Lewis. He was the first black lawyer to practice in Harris County. He was actually born enslaved. He went up to Chicago School of Law, graduated in 1897, was practicing here in the early 1900s in Houston's 4th Ward, Freedmanstown. And in his first trial in Harris County, it resulted in a capital acquittal of 2 black men. So diversity matters. So next question, probably we'll start with the dean. One lasting legacy of Sweatt versus Painter is the Thurgood Marshall School of Law. How has that school grown, and how has it made a difference in Houston's legal community?
I think it's made a tremendous difference in Houston's legal community and in the nation. In fact, in the last couple of decades, we've always been given an award by the American Bar Association as being one of the most diverse law schools in the country. When you look at the percentage of African-American lawyers in Houston as opposed to other cities around Texas, you'll see that we greatly outnumber people in the profession. It's really, really crazy. One of the things Representative Wu talked about, I remember the only time I knowingly was discriminated against. I did a graduate law degree at Stanford. And one day I had a note from a professor. I didn't have a class from him. I had a note to come by his office. He had taught at University of Texas before he came to Stanford. And I went by to see him, and he said, "Jim, you're from Houston?" I said, "Yes." He said, "Well, Baker Botts is interviewing on campus next week." And he said, "I know the guys from my days at UT." He said, "I'd like for you to come by and have dinner with us." I said, "All right." So I go by, we have dinner, everything going well, until one of them says to me, "Douglas," he said, "I don't remember seeing your name on the interview list." I said, "I didn't sign up." He said, "But you're from Houston." I said, "That's why I didn't sign up." Now this is this is 1970. All right, I said, "That's why I didn't sign up." He said, "What do you mean that's why you didn't sign up?" I said, "Man, you and I know Baker Botts is not about to hire black associates." So they spent the rest of the evening trying to convince me that I was wrong. So when they left, the professor said to me, he said, "Jim, do me a favor." I said, "What?" He said, "I know you don't want to do it." He said, "But will you please go interview with Baker Botts?" So I go interview with Baker Botts. About 3 days later, I'm walking down the hallway. I pass his office. He called me in. He said, you know, I owe you a big apology. I said, for what? He said, that Baker Botts thing. He said, I want you to know that I was extremely sincere. So I followed up with them after that interview. And they were just singing your praise about what a wonderful lawyer you're going to be. Anybody would be glad to hire you. So I asked them, so that means you're all going to fly into Houston for a follow-up interview. And they told me, well, some of the younger partners are ready to hire a black associate, but the senior partners are not ready to hire anybody black. That was in 1970.
And that would happen consistently throughout that.
Oh, I don't know how long, and we joke about it. Rufus Comier, who is a lawyer in Houston, he was the first black hire, and we talk about his experience at Baker Botts.
But the really big firms, they're Fulbright, V&E, and Baker Botts, cut a deal. And they said, this year we're going to hire one. And so they hired one. And then the next year, they hired two. And they coordinated with each other. We're talking about coercion. They coordinated with each other that they would hire one that year, two that year, and three. And that set the stage, whereas the law firms, because they were up at 150 or so lawyers. But the lawyers, let me just call some names. The law firm like Bracewell would not hire one. I became the port's attorney in '79. My chairman was Fentress Bracewell of Bracewell, the two Bracewell brothers that had, it was Bracewell and Patterson, which did all of the school desegregation cases, including the 30-year thing with HISD. And at the time I was hired, yeah, representative, that's why it took HISD to 30 years with Make Haste, that whole book, to desegregate it, to desegregate. But when I was hired in '79, my chairman said, you know, great, I'm really glad to have you here. But he told the other commissioner, Howard Middleton, he said, but we're not ready yet. So it was okay for a public entity to hire a black as a general counsel, but it was not okay for the firm Bracewell, because it had like about 60 lawyers. They hadn't gotten to that point where they were going to hire a black lawyer at all. And so, and that's 80, by 1980. So they were working together and ultimately collaborated so that it would get to the smaller firms to ultimately hire black lawyers. But I want to add one other thing about the TSU thing, because I know he did not want to go to the black law school. He wanted to. The community made a difference with Heman Sweatt. They set up a victory fund, a Heman Sweatt victory fund, to pay for him to go to law school. They didn't have scholarships back in those days. And so the community, Dr. Davis, my father-in-law, was the chair of this Sweatt Victory Fund. And that fund actually was where helped people, because they had to sit on his doorstep when, during the case. They had to really put forth an effort to protect him. His wife left him. I mean, he went to get a license and walked up to the thing for his state license, and the officer said, no N-word named Sweatt is gonna get a license here. So, I mean, he suffered tremendously. It impacted him physically and mentally for the process, but he had the community behind him. And that's something that we need to think about what we're doing today in terms of supporting that litigation and getting out there and putting our money behind the litigants who will be fighting these different things that are happening right now. And I just wanted to bring that up about the Sweatt Victory Fund, which still exists with the Pan-Atlantic Council, by the way.
I would add also to what you were talking about, whether big law has changed significantly. I do think that, at least by the time I graduated from law school in the 90s, there was sort of a more of a diversity, equity, and inclusion process for
Yes.
law firms to attract black lawyers and minority lawyers all around. But the same issues that existed sort of in the higher levels of law firms. So I did 29 years in big law and 20 years as a partner with some of the largest law firms in the world. And the issues were the same regardless, whether it's Baker Botts or Reed Smith or any of the big law firms. At the higher levels, there's still very few minority partners. There are very few partners, minority partners of any color on the executive committee that are making decisions related to it. So firms are great about attracting minority lawyers, at least they have been until, now that they've gotten rid of some DEI initiatives. But some of the same issues existed when lawyers tried to grow. So you'd still have really low, basically retention of lawyers, of minority lawyers at the upper levels. And that still exists today. And I was often the only black partner, and definitely the only black equity partner, where you get money from the partnership. So it's still a problem.
Yeah, I just wanted to add, so I was in big law for many years, quite recently, and that's still the case. You're really seeing an effort at the associate ranks that doesn't translate to the partner ranks. And I had this very just interesting experience where the only time that I really saw an effort to push for diversity in the partner ranks was when a client demanded it. So there are clients, certain big companies that really do want to see the law firms making that effort. And I remember distinctly going to a client pitch where it was discussed, we need to bring this one black partner and this one woman partner because I think it was actually United Airlines. They're gonna need to see that. And if the clients aren't demanding it, the law firms are really not pushing it internally.
An additional impact of the Sweatt case is the establishment of Texas's Southern University. Because can you imagine the impact on the community if that university had not been there? If that university, if Texas, the state of Texas had not purchased Houston College and made it a state university, what the difference that would have been to the city of Houston, to the minds that were brought in, the academics and people who came in to this city because Texas had a Southern university. The William Lawsons, the folks who decided that they would come to Texas, Dr. Wardlaw, all these PhDs from Michigan, all the folks from, and they heard about this university, a Biggers. But can you imagine the difference that it would have made in Houston? And for that, we owe Heman Sweatt a tremendous amount of gratitude. And there is not one stick or brick in this city named for Heman Sweatt. And I really think that we need to think as a community what we are going to do, because it's a part of teaching the future of what can happen when you believe. He was 37 years old sitting in a church, and the only reason they picked him was because he was light-skinned and he had a wife. And that meant that he was acceptable in a white environment. So the decision that he made that day on Dowling to actually set himself up as a plaintiff and basically, shatter the rest of his life is something to which we owe him a tremendous amount of gratitude.
One of the things that the stories is that in the beginning, when Sweatt enrolled at UT, he addressed his classmates, and because look, one of the problems with integration was white men were afraid to have black men around white women. And so Sweatt addressed that in the beginning. He said, look, I'm not after white women. I got a wife. So y'all don't have to worry. I have a wife. one of the issues, and when Andrew Jefferson came to Houston in 1968 to work for Humble Law, Andrew was the first African-American lawyer to work for a major corporation or law firm in Houston. That was 1968. So it's not as if African-American lawyers have been a part of the Houston legal profession, at least at that level. The problem we have in the house that Sweatt built, the legal profession is very elitist. We had a guy on our board at one point who was a managing partner of one of the major law firms. So I go to lunch with him. I said, man, look, you know, it's kind of funny. You're a member of the board at this university, and your firm doesn't even interview at the law school. He said, well, Jim, you know, we practice complex litigation. And we only hire from the top law schools, Harvard, Yale, Columbia. We don't, now we do courtesy interviews at UT, but we don't even hire from UT. So I said to him, that's strange. And he said, why? I said, because you graduated from Tulane. But the profession is, at the major law firm, profession is very, very elitist. And they only hire from certain law schools.
You called them out.
And one of the reasons they don't have a lot of African Americans is they don't have a lot of African Americans at those law schools. And so if they don't broaden their pool, it's always going to be just a handful.
Can I just add, just real quick, not just to be the odd person out here, but basically, look, on behalf of the Asian community, we are grateful for what Mr. Sweatt did, and frankly, for what the African American community has done in fighting for civil rights. I've talked about this before, and people give me weird looks about it, but I go and I've told the Asian American community, you would not be here but for the efforts of African Americans, right? And for people who don't know, my community doesn't know this history, is up until 1965, up until the passage of the Civil Rights Act, my people were effectively banned from this country. Like the Chinese Exclusion Act didn't just exclude Chinese, it excluded all Asians and even Asian minors. So even Arabs and Middle Easterners were excluded from this country. Like 105 admissions were allowed per year, right? And so our people were effectively not just not allowed to go to law school, not allowed to become lawyers, we weren't even allowed in the country. But for the Civil Rights Act, we would not have repealed the Chinese Exclusion Act, right? Fully repealed it. And this is like another opportunity for me to once again point out that this ain't that long ago. Right. The first Asian American, the first 10 Asian Americans licensed as attorneys in the state of Texas, half of them are still alive and still practicing. So that ain't that long ago. And even following in the footsteps of Mr. Sweatt, their admissions were not easy, their licensures were not easy, their practices were not easy. And they had to overcome many hurdles. And we are still a long way from equity, and we're now talking about, oh, well, we need to roll things back the other way. It wasn't that long ago. Why are we rolling stuff back?
Yeah. I will have one more question before we take a few audience questions. You mentioned Mr. Jefferson, I think Andrew Jefferson Jr., Jack Yates High School, Texas Southern University. And when he went to the University of Texas at Law, he was the only black student in his class. when he graduated?
But not Jack Yates, Wheatley.
Wheatley, oh, I am so sorry. I know Miss Davis is going to get me. Wheatley, Wheatley High School.
Cash McGardens. I'm
Okay,
Cash
and you're,
McGardens.
and
I
you,
just
you
want to correct it.
said it, I will set it straight. Wheatley, and became the first black state district judge in Harris County in 1974. So we honor Judge Jefferson. Okay, my last question before we maybe take one or a couple of audience, which I lost track, sorry. Here it is, here we go. Here it is. You touched on it, and all of you kind of touched on it, but let's explicitly talk about what the federal government has prioritized, which is dismantling diversity, equity, and inclusion policies in a variety of places, but especially in education. How has this administration's attack on DEI affected the legacy of Sweatt versus Painter and many of the civil rights victories that have followed? And I've heard a few ideas, but any other ideas we can grasp, we need right now.
Look, one of the things I try, both as a faculty member, as an activist, but try to get people to really understand how this country is structured and what the important points are. You know, when we were in high school, we all took a civics course, and you all learned that there were 3 parts of the government. But nobody ever told you that one is more powerful than the other 2. Believe it or not, the person who understood that better than all these great lawyers who served in the presidency was Donald Trump. Donald Trump said in his first campaign, I'm going to turn the Supreme Court around. Because they're the ones who ultimately determine public policy for this country. I teach a course now and then called The Changing Face of Civil Rights. And I start from the proposition that America was created for rich white men. When you really look at history, America was created for rich white men. But the other part of the class is, and we look at cases, every racist policy in America has been approved by the Supreme Court. So it's going to be a long process because you can't do anything until you change the Supreme Court. See, Trump couldn't do all this stuff he's doing if he didn't have the support of the Supreme Court. He knew that the first time around, which is why the most important thing for him the first time was to get his Supreme Court in order. So
Keep Garland on.
right. So I don't know anything to say other than, you know, we can make all the arguments in the court that we want, but you follow all these Supreme Court decisions, because what we become as a country ultimately is going to be determined by what the Supreme Court ultimately decide that he can and cannot do.
There has been a redefinition of words. A redefinition. If you say things now like diversity, equity, and inclusion, it's been redefined to mean substandard, inadequate, unqualified. We have allowed these redefinitions to be said over and over and over again, so much so that when there is a news report that comes out, it's like, oh, if it's DEI, it's unqualified. If it's DEI, it's substandard. There's always that common redefinition that goes along the issue of, it's just blatant supremacy. And we've allowed supremacy to be redefined and to be covered over to say, okay, well then that's equal. If it's the Supreme group, then that means they have an equal choice, a chance. And until we start teaching and redefining what these words mean, then we hit the wall with the media. And that's our real downfall, is that communication and the way we communicate and the way we define words has now been redefined. And the younger set, as we saw with yesterday, the younger set has redefined situations to mean something that they're not. And so it's like saying that there was no insurrection on January 6th. That was just somebody complaining. So that's been redefined. That used to be something that you get convicted for, which is what has happened in another country if you plan an insurrection. But if you plan an insurrection now, it's just, well, they were just complaining. They were just climbing the walls and killing the people and busting up the officers, and that was just a peaceful protest. So we have to be really mindful about words and how they're used. And I don't know how to work on recommunicating and redefining. I have no idea how to do that other than to just start cussing. I just don't.
And
Go ahead.
Can I just add that I think you're exactly on point. It's this taking over of words and concepts. And I think some of it is like we the people don't push back against it, right? And we just kind of accept it. And to the point now where like saying DEI is now just a euphemism for saying the N-word, right? It's just a placeholder, right? Because like, for example, the helicopter pilot that had a crash over in DC. Yeah. And this is a black female pilot who was like highly decorated, renowned, lots of commendations, really like the best and the brightest. Right. And without even looking at her service history, whose fault it was and everything else, they just automatically, well, this is what you get when you get DEI. Well, there's no other information other than the fact that they found out that she was black, right? With no other information. And so, and I think some of the people in the community have pointed that out. But I think like in order for us to push back, we have to go and say, no, you don't get to do that. Like everybody, right? And I have an ulterior motive for wanting us to do that, because when this happens, when they're able to take language that we use normally to say positive things and good things and just do good for the community, and they turn those around, it not only shuts down our conversation, but for them, right now, it creates a new McCarthyism for them. Absolutely. Now they're chasing down all the DEI. Anyone they don't like is now a DEI. Just like anyone you didn't like in the past, they're a communist. They're still doing that, by the way. But DEI is now a bit better attack for them. And they just accuse it. So anything that they don't like, you're fighting for LGBTQ rights. Oh, that's DEI, right? You're fighting for inclusion, like making sure that your company is inclusive. Oh, no, that's DEI, that's communism, right? And we're losing this battle again and again on something that we all should be supporting, right? And I think, like, they've not only found the weapon against us, but they've also found a way to shut us up. And I'm saying, like, look, if they want us to shut up, what should we do? We should be louder than ever.
And I think that discussion about definitions and how we use words, when you want to think about the legacy of this Supreme Court case, I was actually rereading it this morning and to understand the impact. And the first thing I noticed first is how short it is. Most Supreme Court cases are very long. This is it right here. And if you look at what it really does and what it tees up, Brown v. Board of Education, this idea that separateness cannot be equal, right? there's this passage from the Sweatt case, and I'll just read it. It says, "It may be argued that excluding petitioner from that school is no different than excluding white students from the new law school. This contention overlooks realities. It's unlikely that a member of a group so decisively in the majority, attending a school with rich traditions and prestige, which only a history of consistently maintained excellence could command, would claim that the opportunities afforded him for legal education were unequal to those held open to petitioner." And the point what the court was saying and really opening the door for is this idea of equality and separateness. Those things cannot coexist. And so that's why it's so dangerous now that we're starting to redefine what equality means, because we're going to go back to that concept of equality that the Supreme Court at the time clearly saw was completely unequal.
To add to that, one of the things that I like about the decision that I think is important for not just sort of the legal industry, but for all industries, is this pursuit of equality in fact, not just equal treatment without inclusivity, without some sort of integration, which I think is critical because it really says that we have to do more than just admitting minority students or minority workers. You have to include them and have some sort of systemic way of making them be more inclusive. I think that it's also important to note that just having the laws in place is not enough, because we've seen what's happened with these laws, that you really do have to have cultures within organizations that fully integrate all minorities and all diversity, whatever you want to call it. So when I'm talking to corporate clients, I always say DEI is DEAD. I mean, it just doesn't exist the way we thought of it before. But the programs and the purposes and the values, if an organization is truly committed to diversity, I don't give a damn what they call it, quite frankly. If they call it belonging, they can call it, now I think that's the new thing, it's called belonging in cultures rather than DEI. Whatever you call it, as long as it systemically affects and increases diversity, I don't really care what it's called. I think we can talk about the words, but what this new administration has done, which is very different, is he's gone after all organizations that support DEI. So he's attacked corporations. He's filed lawsuits against law firms that had DEI policies. So he's made it a lot more acrimonious. And I think at the beginning, a lot of law firms were afraid. A lot of corporations were afraid. We saw big companies like Walmart, Target, all of these major companies dismantle all DEI in all aspects, not just at the corporate level, but even at the consumer level. And so I think what has made a difference is when the people, particularly let's take the Target example, when the people said, okay, if you're gonna get rid of all these products that affect our community, we're just not gonna buy from you. And we've seen their stock plummet. So I do think that there is a way, as Representative Wu said, for us as individuals to be able to make an impact and to let companies know, let organizations know that this is just not acceptable and that diversity is important to us regardless of what they call it. And whether it's voting with our pocketbook or voting with our ballots, and really trying to make a change that way so that we have real systemic change.
Yeah. The really bad thing about the law is time. Is time. And the time is being used now. If there's an order and then you sue, and then you got to come back and sue again, and then you got to come back, and the delay of the time, and that time costs money. That's what's being used now against any progress or anyone who stands up for it. What we have to do as a community, we have to continually support the process of using the law. No matter what happens, no matter what order, we need to sue. And if you have a problem and the issue about suing because there is a concern that it's going to impact, get some folks who are judgment-proof to sue. You know what I mean? They ain't got nothing to lose. And put them in there and pay for them so that lawsuit can keep going and keep going. Because if we do not use the law to try to straighten things out, it will then become law once it gets to the Supreme Court, and they will then have the right to pull anybody out of a car who looks like they speak Spanish. We have to keep litigating, because this is the one thing that the Sweatt case has taught us. We have to use the law to fight, and we have to be willing to come out of our pockets to do so.
Okay, I think we have time for maybe one or two max questions. So if you raise your hand, and while I'm looking to see, would be remiss if I didn't salute some of our more modern barrier breakers. When my father, Dr. Elwin Lee, was the first black tenured professor at the University of Houston Law Center, 1983. And dear friends of Commissioner Rodney Ellis, we have our dear Mayor, Congressman Sylvester Turner was at Fulbright, and my dear mother, Congresswoman Sheila Jackson Lee, was at Fulbright and went on to their careers after. So they stand on Mr. Sweatt's shoulders as well. So I think I saw, I'll hand mine, because they'll be answering the questions, so, okay.
Just yell out if you got outside voice.
Hello, my name is Michael. One off, I just got to say the greatness in this room is, I feel it, and I didn't know much of what I was walking into, but I'm glad I'm here. This is really amazing, and I want to say that I'm very much dedicated to the progress of this movement. I wanted to know, as an individual, what can I do to, restructure my mind to be into this fight and work towards the forward movement of this, of the rights of our people.
Thank you for your question. Use every moment as a teaching moment. With your age group, it's hard to try to get folks excited because they don't know what they don't know. And the mere fact that you're interested and you're learning, and you can say, this is a tool to be used, utilize that to organize and to push forward and to speak out, if that means getting in the street.
Okay. I'm not going to teach you how to talk to the black community. I'm going to teach you how I talk to the Asian community. I told them, just Professor said, the first thing you do is you educate yourself, right? I mean, even I felt like I was pretty knowledgeable about Asian American history. I was not, right? I taught myself. Next thing I do, I teach others. I teach anyone who's willing to listen, anyone, and I ask them, what do you do next? Now that I've taught you, you teach others, and you keep that going. So what I tell people is, these are the 3 steps. 1, education. 2, organization. Once you have people who know, get them together. Start having discussion groups. Once a month, get your friends together and say, hey, we're going to talk about civil rights. Let's go have a drink. Let's go have, maybe you might be a little young for that. All right, let's go smoke up and let's go have a drink and let's talk about civil rights and what we're going to do. But number 3, education, organization. What's number 3? Action. Action. Raise money for the NAACP to file lawsuits anytime that they feel is necessary. Train yourself to be an attorney. Go to law school, right? Encourage other people to go to law school. Tell people in the community, you need to go to law school, not for you, for us, right? Education, organization, action. Education, organization, action.
Representative Wu, what great comments to lead into what I want to say. I want to talk about a pipeline to law school. I was arrested and convicted of unlawful assembly, failure to disperse, and disturbing the peace at San Francisco State University, along with 456 other people, on January the 23rd, 1969. When I applied for a job at the University of Houston, Deborah Danberg, future state representative Deborah Danberg, was on the hiring committee and saw my resume and said, "He's our boy," and that's how I've been in Houston for all these years. The College of Ethnic Studies at San Francisco State University was supposed to be the beginning. It is the only one in this country. I am asking all of you to team up and get something like that started at TSU and help it to spread throughout Texas and throughout the country. We need programs like that that are a pipeline to law school. Please, you can do it.
Except for now, they're prohibited from doing it under state law because of the anti-DEI laws. You have to call it something else.
Let's give our panelists a warm round of applause. And of course, Erica Lee Carter, the Congresswoman, our policy director. And did our staff at Precinct 1 do it up right? I want Heman Sweatt, if you see him on the other side, hope you see him before I do. That we had a band, we had food, we had a spirited discussion. No matter how hard it may be, no matter what you may be going through, I can assure you, you did not go through what that generation of leaders went through. So thank you. We said we end at 8. We're going to end. We can socialize, enjoy it. The struggle continues. Thank you very much.